Hello, everybody, and welcome to History/Law Bite number 273, dated June 10th, 2021. I'm Walter, your mobile historian and blue-collar scholar. This History/Law Bite is entitled Baker v. Carr, 369 U.S. 186, 1962. For those who are unaware, Baker v. Carr was the landmark U.S. Supreme Court decision that established the right of federal courts to hear legislative redistricting issues. This was previously thought to be an exclusively political topic and therefore outside the realm of judicial review. However, Baker v. Carr put an end to all such presumptions. So as we begin this decision, let us begin in the same manner that the Supreme Court itself does. All rise. The Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Please be seated. So let's get into Baker v. Carr. So, in this case, we go back to the early 1960s state of Tennessee. And the Tennessee state constitution had a requirement, that required that all of the state's legislative districts be redrawn every 10 years for apportionment purposes in the Tennessee General Assembly, the state legislature. This was so that the districts could be substantially equal in population. However, this had not been done, since 1901 as a result of the 1900 federal census, So our petitioner here, Baker, asserted this in his complaint. Now, Mr. Baker was a Republican mayor of Millington, which is in Shelby County, Tennessee. And he made it known in his complaint that in his Shelby County district, it had roughly 10 times the population as many of the state's rural districts. In the South, you have a whole lot more rural areas than you do urban areas, You certainly did back in the 1960s, And in essence, because of this, rural citizens were vastly overrepresented compared to urban citizens, Something that would be viewed as unthinkable today, Also, the fact that the state had not redrawn the districts in, 50 years at that point, that's also something that would be unthinkable in the modern era. So Mr. Baker argued that this type of disproportionate representation violated, his equal protection of the laws as required by the 14th Amendment to the U.S. Constitution. So as such, he sued the Secretary of State of Tennessee, Joe Carr, and he only sued Joe Carr by virtue of him being ultimately responsible for the state's elections and the publication of district maps. The state of Tennessee argued that state legislative redistricting was exclusively a political question, not a judicial one, as the court itself had held in 1949 in the landmark, now reversed case of Colgrove versus Green. So, the issue presented before the Supreme Court of the United States was a simple one, all things considered. And that was, did the federal courts have jurisdiction over questions of legislative apportionment? Or are such questions exclusively political and outside the realm of judicial review? So we got, ladies and gentlemen, a 6-2 decision in favor of Baker, And the opinion was authored by the legendary Lion liberal, Justice William Joseph Brennan Jr., one of my personal heroes, as you all already know. Justice Brennan's opinion had the following points, First and foremost, legislative redistricting issues were not inherently political questions. but instead were justiciable, which means able to be decided by a court of law, okay, and thus subject to review by the federal courts. Okay, so Brennan is throwing out the political question assertion by the state of Tennessee. He also held that the U.S. District Court, which is where this began, had jurisdiction of the subject matter at hand, okay, and of the federal constitutional claim asserted in the complaint, all right? Appellants thus had standing to maintain this lawsuit. The complaint's allegations of a denial of equal protection of the laws presented a justiciable constitutional cause of action, okay, upon which appellants are entitled to a trial and a decision, okay? Cause of action, the ability to file a suit in a particular circumstance, all right? So in repudiating the political question arguments, Justice Brennan effectively reformulated the existing political question doctrine of the day. He outlined 6 factors to assist in determining matters that were essentially political in nature. And I'll read, an excerpt from Baker versus Carr for you, okay? So it reads that it is apparent that several formulations which vary slightly according to the settings in which the questions arise may describe a political question. Although each has one or more elements which identify it as essentially a function of the separation of powers. Prominent on the surface of any case held to involve a political question is found a textually demonstrable constitutional commitment of the issue to a coordinate political department. That's the first one. Or a lack of judicially discoverable and manageable standards for resolving it. That's the second one. Or the impossibility of deciding without an initial policy determination of a kind, clearly for non-judicial discretion. That's the third one. Or the impossibility of a court's undertaking independent resolution without expressing lack of the respect due coordinate branches of government. That's the fifth one. Or an unusual need for questioning political adherence to a political question made, okay, or the potentiality of embarrassment from multifarious pronouncements by various departments on one question, okay? That's the last, okay? So those are the 6 standards that Justice Brennan outlines for political questions, okay? Questions that essentially were off limits for the courts, all right? And unless they met at least one of these standards, the subject at hand was not exclusively a political question, okay? So he goes on to say, unless one of these formulations is inextricable from the case at bar, there should be no dismissal for non-justiciability on the ground of a political question's presence. The doctrine of which we treat is one of political questions, not one of political cases. The courts cannot reject as no lawsuit a bona fide controversy as to whether some action denominated political exceeds constitutional authority. The cases we have reviewed show the necessity for discriminating inquiry into the precise facts and posture of the particular case, and the impossibility of resolution by any semantic cataloging. Okay? So Brennan is making it clear the courts can't just, throw out a matter just because it's got political aspects to it, okay? And it had to overwhelmingly be a question that is for exclusively the political branches to deal with, for it to be out of bounds for the courts to decide or even review in any way, shape, or form, okay? So the courts cannot reject as no lawsuit an actual controversy as to whether or not some action political exceeds constitutional authority. Okay? If it's a controversy, all right, and it clearly had, justiciable features to it, then the courts could indeed pass judgment upon that controversy. Okay? So Justice Brennan went on to summarize the opinion that, he concluded that the complaint's allegation of a denial of equal protection presented a justiciable constitutional cause of action upon which appellants are entitled to a trial and decision. The right asserted is within the reach of judicial protection under the 14th Amendment. Okay? So the judgment of the court here, all right, the Supreme Court, reversed, all right, the district court, all right, and the cause itself was remanded back to the district court for proceedings consistent with the court's opinion here. So in this case, the court reversed and remanded, all right, because the district court obviously ruled against Mr. Baker, and the Supreme Court sent it back for retrial, all right, reversed and remanded, all right. Not everyone agreed with Justice Brennan's rationale in this case. Two prominent dissents were filed by Justices Felix Frankfurter and John Marshall Harlan II. The court's two conservatives at this point. Very conservative justices. Justices Frankfurter and Harlan strongly disagreed with Justice Brennan's decision and argued that the majority opinion had casted aside both history and law, all right? That the majority had thrown out the concept of judicial restraint and violated the separation of powers between the legislative branch and the judiciary, all right? Their opinions obviously have not carried the day since this time. Now, some interesting things about this case. This was one of the most agonizing decisions of the Warren Court, period. Okay, and it was so stressful for Justice Whitaker. You notice I said this was a 6-2 decision. Justice Charles Whitaker, who is rarely discussed, this case was so agonizing for him that he recused himself from it for health reasons and eventually left the court because of this decision in March of 1962. That's deep, isn't it? This case caused a member of the court to simply say, screw it, my health is more important, and he bounced, okay? Interesting thing, Whitaker suffered a mental breakdown. He was, really stressed out about this case, and, he had developed severe writer's block, which also had led him to leave the court. So, additionally, when this case was argued in April of 1961, very first time, there was no clear majority for either side. So it had to be put over for a re-argument in October of that year. And only then did a court majority form. All right. So the legacy of Baker versus Carr is, one that cannot be overstated. Baker versus Carr essentially opened the floodgates for a massive amount of litigation regarding state legislative redistricting practices, okay? And two of its most prominent progeny cases are Reynolds versus Sims and Westbury versus Sanders, decided a couple years later, all right? Baker versus Carr essentially, was the foundation case that enabled, all right, legislative redistricting practices to be challenged in federal court, okay? And, lawsuits continue to this very day, to ensure that redistricting practices comply with the federal Constitution, the 14th Amendment primarily, and, the Voting Rights Act of 1965, all right, and other, I'm sure, relevant federal laws, okay? So this was a very important case, and the legacy of Baker versus Carr, was, to give, the initial speech and formula for the one man, one vote principle, all right? So proportionate representation, all right? The importance of that is, like I said, it can't be overstated. We have, the Constitution requires equal protection of the laws, and state legislative redistricting practices are not outside of that realm, okay? And the Supreme Court, has required this, in the litany of different cases since Baker versus Carr 59 years ago, all right? And the court continues to do so, like I said, to this very day. One man, one vote, proportionate representation, all right? That is the key. All right, so overrepresented places and underrepresented places, is not acceptable under the court's jurisprudence in this area, okay? The court has required the principle of proportionate and overwhelmingly equal representation, all right? So, any questions or controversies about Baker versus Carr, okay, leave them down below and I'll be happy to answer them. All right, so once again, the basic holding of this decision was that, Baker versus Carr, okay, established the right of the federal courts to decide and hear cases on legislative redistricting matters. All right, things that were previously considered to be political questions exclusively, and thus out of the realm of the judiciary, to deal with, okay? Baker versus Carr put an end to that and essentially opened the doors of the federal courts to assure that legislative redistricting practices were in compliance with the U.S. Constitution and other relevant federal laws, okay? So again, I thank you for listening. If you've not subscribed to my YouTube channel, please do so now. It will be greatly appreciated. And if you gained some insight from this video, which I certainly hope you did, learned a thing or two, drop me a like. I would appreciate that more than you'd ever realize, all right? The more you like, the more you subscribe to my channel, the more I get put out there, which is the goal, all right? So take care, stay safe out there, keep on learning. All right, and remember, I live and breathe this stuff. Case law is delicious to me, right? And I'll talk to you at the next video. Peace.